The courtroom was buzzing quietly as Judge Martinez called the session to order. The case had already garnered local attention. Malik Bennett, a 35-year-old civil rights advocate and law scholar, was suing the city police department for wrongful arrest during a peaceful rally. Across from him sat Gloria Pearson, a notoriously aggressive prosecutor known for her sharp tongue and subtle racial bias. She had built her reputation on winning difficult cases, often by exploiting loopholes and deploying trick questions to confuse defendants and witnesses alike. Today, her target was Malik himself, who had chosen to represent himself. From the moment the trial started, Pearson's tone was dismissive. "Mr. Bennett, are you aware of the consequences of falsely accusing officers of misconduct?" Malik answered with a calm, steady voice. "Yes, ma'am, but I am confident in the facts I will present." Pearson smirked, sensing an easy win. When it was her turn to cross-examine Malik, she leaned in and said, "Mr. Bennett, you've made serious claims against the police department, but do you even understand the legal precedents governing police conduct?" Malik met her gaze without flinching. "On the contrary," he said, "I'm intimately familiar with them." The prosecutor raised an eyebrow. "Let's test that, shall we?" She pulled out a thick legal brief and began reciting a convoluted passage from Terry vs. Ohio, a foundational case in stop-and-frisk law. She then asked, "Based on this, would you say the officers in your case acted reasonably?" Malik held up a hand to stop her. "If I may, Your Honor." The judge nodded. Clearing his throat, Malik began. In Terry vs. Ohio, 392 U.S. 1, 1968, the Supreme Court held that a police officer may stop and frisk a person if the officer has reasonable suspicion that the person is involved in criminal activity and may be armed and dangerous. However, such searches must be limited in scope and duration to ensure they do not violate the Fourth Amendment's protection against unreasonable searches and seizures. He paused, flipping to a bookmarked page in his notes. Furthermore, the court clarified that reasonable suspicion must be based on specific and articulable facts, not just a hunch or a person's appearance. Pearson tried to interrupt. Malik raised a finger and continued without hesitation. In the case of Illinois versus Wardlow, 528 U.S. 119, 2000, the court ruled that unprovoked flight in a high-crime area could contribute to reasonable suspicion. But the context must be carefully considered. Flight alone is insufficient to justify a stop. He looked directly at Pearson. In my case, none of the officers had any specific or articulable facts before detaining me. I was standing peacefully, and I complied fully with their requests. The courtroom fell silent. Malik didn't stop there. He recited nearly the entire relevant section from Wren v. United States, 517 U.S. 806, 1996, explaining how the court emphasized that subjective intent of the officers does not excuse violations of constitutional rights. Pearson's confident smile faltered as Malik connected each precedent directly to the facts, showing clearly how the officers had overstepped. "Mr. Bennett," the judge said, "your understanding and citation of these cases are impeccable." Pearson, now visibly unsettled, tried a last attempt. "But Mr. Bennett, are you not ignoring the fact that you were asked to leave a public space by officers?" Malik responded, "Public space rights cannot be arbitrarily revoked without due process, and peaceful assembly is protected by the First Amendment. The officers had no lawful grounds for my removal." By the end of the trial, Malik had methodically dismantled the prosecution's claims with an airtight foundation of case law. The jury deliberated briefly before returning a verdict in Malik's favor, clearing him of all charges and awarding damages for wrongful arrest. Outside the courtroom, Malik was hailed as a hero, proof that knowledge and poise could overcome prejudice and trickery. Asked how he prepared, Malik smiled quietly. "I grew up in a neighborhood where respect had to be earned, not given. I learned early that the law can be a weapon or a shield. Today I chose to wield it wisely."